Okay, welcome to the Legal Doc Guy podcast. I believe we are 82 days away from the February 2026 California bar exam. And today we are going to talk about question 2 from July 2012, which is a community property / professional responsibility question. Now, before we get into that, I'm going to show you guys, for those of you who don't know, how to go onto the State Bar's website and pull up examinations so that you can follow along. I recommend that you read the question, just stop the video, read the question, and then follow along with me as I go through the question. Okay, so in order to do that, you see here, this is the State Bar's website. So what we do is you just go into Google and you could just put State Bar of California, or you could even just put State Bar, and you'll see when it comes up, it says Cal Bar, blah, blah, blah. Nothing there, nothing there, nothing there. State Bar of California, look at that. Right there, you get public. I don't think I ever seen this one. It does say State Bar California, but this is what you want right here, this page. Okay, it'll actually pop up a lot easier if you just put State Bar California like that, and the page will pop right. Look, it didn't pop up right here. State Bar California. Okay, this is their official site, .gov. You just click on that. Okay. I don't need this anymore. And you go here to admissions. Boom. Okay. Then up here where it says examinations, you just click on that. And you'll see here past exam questions and selected answers. You could also view dates and application deadlines. So for the 2026 February bar exam, you'll see here that we've already gone past, but it looks like we've already passed the timely filing deadline, which is November 3rd, which was November 3rd of 2025. We're already past that date, but you still have a final filing deadline that you could file, or you could apply for the February bar exam no later than January 2nd. I believe they charge you like a late fee. Knowing these jerks, it's probably about $100. So you're going to end up paying, I don't know, about $950 or something like that. $950. Let's see. And this is for the February 26th California bar exam. Legal specialist examination. I'm not sure what that is. And then you have here first year law students exam. So if you're taking the baby bar, you're going to be taking it, I believe, in October. It's sometime in October, if I'm not mistaken. It's been a while. I think I took it in October of 2014, something like that. I don't remember. However, your filing deadline is long gone. Oh, because October already came and gone. So they haven't updated for the, I believe they give it again in June. I forget when the baby bars are given, but it's given twice a year as well. If you have any questions about the baby bar, feel free to ask me. I'd be happy to give you a rundown on what that's like. I did take that exam and pass it. Okay, so I just want to show you deadlines, but we can go back to examinations up here at the top. I think you can see my cursor. I wonder if I can make my cursor bigger. I'll figure that out another day. But you just go click here on past exam questions and selected answers. Now this first group of questions here, this first group is just going to give you only the question itself. But if you come down here, it says essay questions and selected answers. It'll give you the question and the answer. So this is a larger PDF. Down here you have your performance tests and selected answers. So if you want to see past performance exams that were given for that year, So obviously there's only one performance exam per session. For the written essays, they give 2 examples. I don't recall if they give 2 examples. I believe they do give 2 examples, but obviously there's only one. And then here's the first year law students examination questions. These are all first year subjects: torts, criminal law, and contract questions. Sometimes there's remedies, or usually there is remedies. Essay questions and selected answers. I believe that's for the first year exam. So same concept. And then multiple choice questions and answers, blah, blah, blah. Who cares? Anyway, so what I want you guys to do for today is we are going to go into July 2012. All we need for our purposes here is question 2. So I'm just waiting for this bad boy to load up. Okay. Now, it's kind of slow. Okay. So you'll see here, question 2. I don't need this. Okay. So here we are. Let me see if I could blow this up a little bit, so you can see it a little better. Okay. Now, like I said, at this point, you can pause the video, go onto the State Bar's website, just like I showed you, pull it up, and then read the fact pattern. Familiarize yourself with it. Read it a couple of times at least. Try to outline it. Spend about 10 minutes trying to outline this. Try to see if you could figure out what the issues are, which I think is important. I did the same thing, so I'm going to go off of my notes. Okay. So I'm assuming that you've already read the fact pattern and you know it pretty well at this point. Okay. So I'm just going to run through it. So obviously our first question here is Wendy's interest in the family home subject to damages recovered for injuries to the pedestrian? Okay. And answer according to California law. So the first thing we need to talk about here when you're drafting an essay is presumptions under California law relating to community property assets. Those assets could be anything from income to real property, personal property. Doesn't matter, but we want to let the reader know that there's a presumption that property acquired during the marriage, and that's all property, could be anything, is considered community property. So that means that each spouse holds present and existing and equal interest in the community property. And that goes for debts as well. So debts incurred during the marriage are community debts and are generally payable from community property. Okay. So you can just let the reader know that, you just put a heading that says presumptions. At least that's what I would do. I would just put I put a heading. I put like a 1. Let's see if I can do this. So I'm going to pull this up here. This is a blank piece of paper here. Let me see if I can get this up. Okay. So basically I would do this. I have the question, as you know. The question is Wendy's interest in the family home subject to damages recovered by the pedestrian? So that's exactly what I would do. I would just type that out. I would just say, is Wendy's interest in the family home subject to damages recovered by the pedestrian? Maybe a little question mark like that. If I was writing this on the essay, I might, first of all, correct this here. They usually, on the bar exam, it has options like this, kind of like a Word format. It isn't Word, obviously. It's ExamSoft is the program that they use, and it has functions or features like this ribbon up top. A lot of features that are similar and familiar to here. Okay. And I would just highlight the text, and if it allows you to, I would capitalize each word like that. Or if you want to, or if you prefer them all to be uppercase, you just put uppercase like that. Okay. So, but you have your heading. Okay. And then I would just let the court know that there's a community property presumption. So perhaps if you wanted to, you could put an A like that, and then you could just put community property presumption. Hope I spelled that right. And then boom. Okay. And then you just let the court know for, we IRAC, obviously. So you'd want to let them know something like, in California, all property acquired is probably the right word. Acquired during the marriage is community. Is how you spell that? Community. Oh, how'd that happen? That could totally happen when you're typing in the bar exam. So make sure that you have a keyboard or computer. The keyboard works for you, where it doesn't. Community property is because community property, and I'd probably, because I don't want to type out community property throughout the whole exam, I might put that there like that, and then a period. Boom. There it is. And I mean, you could add something to that, like what I talked about, existing debts, or, that each spouse holds like a present and existing and equal interest in the community property during the marriage, right? If you want to go that far. But the main concept that you want to let the reader know is that in California, all property is acquired during the marriage is community property. Okay. So obviously in the exam, you may even want to bold that right there. Give it a nice look. Make sure you have good spacing, right? Good spacing. But that's essentially what you want to let the reader know. Okay. We don't really have to get into analysis because we're just letting the reader know that we understand that there's a presumption, a community property presumption, that in California, all property acquired during the marriage is community property. Okay. The next thing we want to let them know, and, perhaps putting A and B is not the best thing, but I just kind of like breaking stuff up, and there should be proper spacing. So A and B might be a little close to each other. I'm not quite sure how to do it on ExamSoft, but I would just give it enough space here. Spacing is your friend. Okay. So here, when we go back to, let's see if I can get that up. So you see here, the question is asking us about Wendy's interest in the family home. Is it subject to damages recovered for injury? So that recovered here, this word recovered means that I'm assuming you've read the fact pattern, but the pedestrian sued and recovered damages for their injuries. Okay. So now the question is Wendy's interest in the home subject to those damages? Okay. So what is this? What is it? Why would it be subject to damages, right? In community property, when we're talking about in this particular fact pattern, it's community property, and you're going to see, because this question is asking you about a tort, right? Subject to damages, okay? That's a tort type of word right there. So obviously, her husband, Hal, got drunk one night, went out, he says here he was, started driving and struck a pedestrian. That's a tort. Okay. That's not a contract. Okay. Now, the interesting thing about the bar examiners is that they're going to draft a question that's going to hit both sides of the same issue. So the first question is asking you about, is her interest in the family home subject to a tort? And then the second question here is asking you if her interest in the home is subject to payment for house legal fees, which is what? It's a contract. Tort, contract. First question is a tort. Second question is a contract. And they have different rules. Okay? That's why they're testing it this way. But they're similar, right? It's all about her asset, her interest in the home. Both of them are about her interest in the home. Is she going to have to pay for the damages for that pedestrian for getting ran over by her drunken husband? And is her interest in the family home subject to payment to house legal fees? Because he entered into a contract unilaterally with his attorney and agreed to his attorney placing a lien on the property, right? Okay. So then that means then that we want to have a heading here that lets the reader know that we understand that this first question is asking us about a tort. Okay. So you could put a simple heading like community property for torts. And that's it. Boom, boom. That might be too much space right there. Let's take that away. Bam, 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 bam. We're back here. Okay. So then we need to put a rule. Okay. So here we could put a rule, something like under California family code, if you know it, section, I believe it's 1000 to 1002, like that. The community, I don't like what does say the community estate. Estate is liable for a spouse's torts committed during the marriage. Okay. But we also need to let them know. Now, here's where you get the points. Okay. So I'm not going to do this for the whole essay. I'm just wanting to show you how to put up some paragraphs together, how to deal with an issue. Okay. But so we know here, I don't think I spelled that right. I don't think it should be like that, but we'll just leave it that way. That doesn't make sense. Or that little comma shouldn't be like that. It should be like the comma or the whatever you call that right there, or the hyphen. I don't know what you call that. But anyway, man, it's been so long since I've been in school. But this little thing up here, apostrophe, man, I forget what those are called. Anyway, it goes right there. Okay, spouses, I say under California Family Code section 1000 to 1002, the community estate is liable for a spouse's torts committed during the marriage. So keywords here, during the marriage. Okay, so we need to let the reader know we understand the difference between how it works if the tort occurred during the marriage and how it works if it wasn't committed during the marriage. So what I would do is I would just probably finish up a rule here, which just lets the reader know that we understand the difference. And we could just put something like, however, whether, community or separate, man, I gotta learn how to spell, property is first applied depends on whether the tortfeasor, you need to learn that word, tortfeasor, spouse, was acting for the benefit of the community when the tort occurred. Okay. So get rid of this. It's a delete double word. This is supposed to be community. Okay. So this right here is the rule. So I would just let the court know whether, or let the reader know, the examiners know, that you know what happens if the tort occurs during the marriage or if it occurs, whether it happened for the benefit of the community. Here's the, when it occurred. Here's the key language right here. I'm going to underline that. Okay. So benefit of the community. So what's the difference? So the first sentence talking about the community estate is liable for the spouse's tort committed during the marriage. Okay. So that's the first key. First thing we're going to have to determine is when the husband gets into that accident right here, how went on a drinking spree, started driving and struck the pedestrian, we're going to have to determine whether or not at this point there was a marriage, whether they had intended, whether or not there was a valid, or whether or not they were legally separated or not. Okay. And there's a two-pronged test to that. That I guess I could talk about briefly. So what is the two-pronged test to make that determination? That's really for the analysis moving forward. I would probably put that under the next heading. So actually first, let's go back and let's talk about the difference between if it was done for the benefit or not. Okay. So I probably wouldn't write it this way, but we can just put you could just put a bullet point. Okay. And so we'll say the tort was committed for the benefit of the community. Okay. We'll just put it like that. Okay. No big deal. This means that the liability would be satisfied first from the community property assets, and then from the tortfeasor separate property. Okay. So in other words, whether or not the court is going to exhaust separate property from the tortfeasor spouse first, or whether they're going to exhaust the resources of the community first, depends on whether or not the actions taken or the harm done, the tort, was for the benefit of the community. Okay. So that means the second one, the tort, was not for the benefit of the community. Okay. Just going to put that real quick. So we're letting the reader know if the tort was committed for the benefit of the community. That means, so we could put an equal sign here, I guess. This is, now I'm just kind of outlining, means that, that community property, I guess you could say, the court would apply community property first. So I'll just put first, like that. Okay. Then tortfeasor's separate property. Okay. Now, if the tort was not for the benefit of the community, that would mean the court would apply the separate property of the tortfeasor spouse first, and then community property to pay off the debt. Okay. So then that means we need to figure out, now I'm just going to talk about it, because obviously next we would go into our analysis, right? I would go into analysis. That's what I would do. I think we set up the rule here. So we know for the purposes of the first question, is Wendy's interest in the family home subject to damages to recover for the injuries to a pedestrian? That's all we got to figure out. So we set up all the rules. Okay. We set up the presumption that all property acquired during the marriage is community property. Okay. So first question here, we know that the house was purchased during the marriage because the fact pattern tells us down here in 1, 2, 3, 4, that Wendy, it says here, right here, second sentence, his only asset and interest was the family home, which he and Wendy purchased during the marriage. So what are we talking about? We're talking about the family home right here. Family home. Okay. And then it says it was purchased by Wendy and Hal during the marriage. So going back to our community property presumption, we know that we could just add a fact here that the family home, or you could say the facts tell us that the family home were purchased during the marriage, making the family home community property. Okay. So now we've established that the home is community property. Why? Because our presumption is that all property acquired during the marriage is community property. The facts tell us that the family home was purchased during the marriage, making the family home community property. Simple as that. Therefore, it's community property. You don't have to do all that. Not to say you don't have to ever do it, give conclusions. You do. But there's really no conclusion here. We're just letting the court know that the family home was purchased during the marriage, making the family home community property. Now, our next section, community property torts, the reader knows that we've laid out this rule of torts in the heading, letting the reader know that we understand that the first question here is asking us about a tort. Okay? Damages. Okay? It's about damages. You don't have damages in contracts, which is question number 2. But for question number 1, we're letting the reader know that, hey, we're talking about a tort here. Okay? So we let the reader know that under California Family Section 1001 through 1002, the community estate is liable for a spouse's torts committed during the marriage. Okay? So there's the key language here. During the marriage. So first thing I want to let them know in my analysis, which I probably wouldn't draft it exactly like this if I was doing an essay on the bar exam, but this is just to try to make it simple, is I would say what the facts tell us. We don't even have to do that because we've already done it up here. We let the reader know that the family home was purchased during the marriage. But if you want to, for the sake of thoroughness, you just take this in the bar exam. They have a copy paste feature and you just repeat yourself right there. The family home was purchased during the marriage, making the family home community property. Okay. So, but that's actually not what we need to determine. We know that the home was purchased during the marriage, but now we really need to want to let the reader know is that we understand that community property assets will only be used first to satisfy that debt is if the tort was for the benefit of the community. Okay? So we could just put some facts here. Simply that to bring this down a little bit, we could just let the reader know straight from the fact pattern. I don't have let me see. I think I have the fact pattern here in front of me. We could just let the reader know that, let's see. So I would probably use the facts that Hal, or just an H, or just H, like that, went on a drinking spree, as it says, started driving, and struck pedestrian. Okay? Those are his actions. That's what happened. And then I would add a sentence saying that, what did I put earlier? I said basically that it's not, well, obviously it's not for the benefit of the community. So you would just say, I guess you could just say that Hal was not acting for the benefit of the community. I would probably add something to the front of that. Hal was acting reckless. Anything else other than reckless? I guess you could just put that, and was not acting for the benefit of the community. You know, Hal was not, I don't know, like he wasn't earning money. You know, it's not like he was earning income, right? It's not like he was doing something. It was like his actions were like unrelated to income. So I guess you could just say that his actions were unrelated to earning income. Why income? Well, because something like earning income would be something that benefits the community, right? But he wasn't out there driving around earning money. He was out there getting drunk. In real life, he was probably out there getting drunk, snorting coke. Who knows what he was doing? Maybe partying with his friends, I don't know. I don't want to say he was getting prostitutes. That's kind of getting really out there, because remember, we don't want to add facts to the fact pattern, right? And that could happen when you're on the bar exam and there's time restraints, and you know, you read this only once or twice, and then you just start making assumptions. That happens all the time. Okay? So we stick to the fact pattern. We just say, but we can say his actions were unrelated to earning income, because they weren't related to earning income. He was being reckless. He was just being reckless. He was just driving drunk, and he hit a pedestrian. So we established then up here that it was not for the benefit of the community, right? It's in our rule. So we put facts that support our rule. We attack the elements. We apply the law to the facts. Here's the law. And we add some facts. He was acting reckless and not acting for the benefit of the community. Boom, boom. Here's acting for the benefit of the community. And here it is down here. Boom, just like that. Okay? And so then we probably also want to let the reader know, since he was not acting for the benefit of the community, the liability for the pedestrian's injuries are going to be satisfied first from Hal's separate property. So you could put last line here, since H was not acting for the benefit of the community, how would I write this? I just said it. Liability for the pedestrian's injuries would be satisfied from house separate property. Okay. Now, so the thing here is that Hal doesn't really have any separate property, right? And you know what? Actually, we need to address another issue as well. So let me see. So we should probably classify the home, which we kind of did here. We set up here that the family home, or the facts tell us that the family home was purchased during the marriage, making the family home community property. Okay. But we could have a heading that basically just lets the court know. Is that C? Just let the court know. Is that C? Let's see. Okay, here's our analysis here. All right, so C, we just put classification, because that's important. And I would probably put like a line, family home, like that. Okay. And then just let the reader know again. So I just take my copy and paste right here. Here it is again. Boom. Purchased during the marriage. Boom. Super easy. Bold that. Okay. Bolded. Looks good. I should probably separate this. When you're writing an essay, you really want to make sure I like using point 24 when I draft in legal writing at work. I always put 24 space here. That's basically going to make you skip a line. Okay. It's going to give it space. Okay. This might not even be enough space. There should always be a lot of space. Bar examiners like space. Easier on the eyes. Judges like space between paragraphs. Okay. You can literally just take all these paragraphs and make them like this. Okay. So it's not all bunched up. Boom, 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 like that. Okay. And then you would just let the reader know, as far as classification goes, that Wendy has 50% community property interest, which is generally reachable to satisfy community debts. But only after Hal's separate property is exhausted. And that's because, as we said before, it was not for the benefit of the community. Okay. Boom. 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 Sorry, it's kind of a pet peeve. All right. So anyway, we could have a new heading now. Because we need to talk about the effect of the separation. Separation, like that. Okay. Now, we need to talk about this because we need to let the reader know that we let them know that they purchased a house during the marriage, but we haven't really talked about whether or not the tort occurred during the marriage, right? Because that's a huge issue. We need to let the reader know that, yes, assuming that everything happened during the marriage, all this is going to apply. Because this only applies if it occurred during the marriage, right? See? Liable for spouse's torts committed during the marriage. So I don't know if I would have addressed it first. We're just kind of letting the reader know that we know what the rules are. Okay. I don't have to go straight into my analysis. I just letting the reader know, hey, I know what, that looks better. I know what the rules are. I know where I am. I'm in community property. There's a community property presumption that property acquired during the marriage is community property. I'm letting them know that, hey, I understand that this question is asking me to identify that this is a tort question, that they're asking about liability for a tort as opposed to a contract. And I let them know how the money or how the assets, community property assets or the separate property assets, how the court would determine whether or not they go for community property first or whether they go for the tortfeasor separate property first. We let the reader know, hey, we know how this is done. Okay. And then down here, this was basically asking, this part here is basically establishing whether or not it was for the benefit, right? So when drinking on a drinking spree, started driving and struck a pedestrian, he was not acting for the benefit of the community. And we're just letting the reader know that, okay? We classified what the home is, the family home. The facts tell us that the family home was purchased during the marriage, making the family home community property. We're also letting the reader know about the effect of the separation, okay? But we haven't really talked about this, and this probably be mostly analysis. Most of the analysis is going to be fact specific, okay? So let's look at the facts. Let's see. So, and we're talking about separation, okay? She insists that he move out of the family home and not return until he completed alcohol treatment program. So he moved out but did not obtain treatment. So out of this whole thing, this is all talking about him, the separation. But the most important fact from this whole paragraph, I think, is that he moved out. Okay. So if we take that and we put, he moved out. Okay. That's the first thing. He moved out. I think the facts tell us that he moved out a year ago. See up here, he moved out a year ago. This happened a year ago. So he moved out a year ago. So we could even let the reader know that we're paying attention. A year ago. Okay. So he didn't just move out. He moved out a year ago, and he was supposed to get treatment, but he didn't do it. Okay. So wife could argue, hey, he moved out a year ago and he was supposed to get treatment. He didn't get the treatment. And therefore I had no intent to reconcile our marriage. I had no intent to get back with him or to resume the marital relationship. So we were separated when the accident occurred, right? That's what she wants to say. She wants to say, look, he moved out right here in paragraph 2. He moved out and he did not obtain treatment. I told him, she insisted that he move out of the family home and not return until he completed an alcohol treatment program. She tells him she was not going to tolerate his drinking any longer. She insisted that he move out and not return. Right here, not return until he completed an alcohol treatment program. Now, when you read that, does that sound like she's saying our marriage is over? I'm going to say no, because she's saying, look, there's a possibility that if you complete this program, this alcohol treatment program, that you can come back. But she's saying you can't come back until, she does say you can't come back until you complete the program. And the facts do tell us he did not obtain treatment. But that in and of itself doesn't prove that she intended to end the marriage at that point. Okay. There has to be certain words that have to be given to let the reader know that you understand that she did not expressly give the intent that she was going to seek divorce. See, she doesn't say she wants a divorce until after he hits the pedestrian, because in paragraph 3 last month, Hal went on a drinking spree, started driving and struck a pedestrian. It wasn't until after he struck the pedestrian that she said, or that it says here that once she learned of the accident, she told Hal that she wanted a divorce. So the important thing here is that it's a 2-pronged test. Okay. Effect of a separation. So I would probably just go like this, put a little 1. The first thing is, there has to be a physical separation. Now, do we have a physical separation? Yeah. the fact pattern tells us that he moved out, right? There it is. He moved out. So this right here, I'd probably put that right there. He moved out a year ago. There is a physical separation. Okay. Now, number 2 is essentially she has to have the intent not to resume the marital relationship. Okay. That is the key. Okay. So we know then that she didn't give that intent or express her intent to divorce until after Hal struck, is the word they use in the fact pattern, pedestrian. Man, my typing sucks. Okay. Right? So that is so what does that mean? Well, you can give a conclusion here that because the accident occurred before the intent to permanently end the marriage, that the accident occurred during the marriage itself for community property purposes. So that's exactly what you would that's exactly what you tell the reader. You would just say something like that. Because the accident happened before she said, I want a divorce. And the fact pattern here, you see, she says, I want a divorce. But it's not until after Hal struck a pedestrian. So had she said, I want a divorce before he struck a pedestrian, it'd be different. But that's not what happened. He struck a pedestrian during when the marriage was still technically valid. Why was it valid? Because although there was physical separation, she had not yet formed the intent necessary, which would demonstrate that she did not intend to resume the marriage. Okay? So that's the effect of the effect on the separation. Okay? So in other words, they are not legally separated. There's no like official date of separation, because at this that would be significant at this point because the accident occurred beforehand. Okay, so then I would just have an app like another heading application or something like that. And so why the application? So the application, we're basically just gonna let the court know that because it happened during the marriage. So because it happened during the marriage, the accident, and because it was not for the benefit of the marriage, that the court is going to apply first house separate property, okay, and then go after the community property, okay. But her separate property would be okay. In either situation, the court's not going to be able to touch her separate property, okay. But the facts also tell us that he's unemployed. Hal has no money. So how is he going to, the court has nothing. The facts tell us two things, okay? The first thing, I know I read it here. It says here somewhere that it's his only asset. I know it does. Let me see. His only asset right here. His only asset is the interest in the family home. He's unemployed, and his only asset is a family home. He's got no money. If he had money, it wouldn't say his only asset. It would say his only asset is a bank full of money. He's got money in the bank, or he's got the house. But it doesn't say that. It says his only asset is the interest in the family home. Okay? So that means then Hal's got no. So just put here, Hal has no separate property. Okay? So then you look you don't want to write this, but I'm just going to say you look to the community property. Okay. So that means that we can exhaust that Wendy, the wife, is exposed. They can go perhaps after his interest in the community property first, his half of the house first. So if it was liquidated, the house was sold, they would go for his half of the community property first. If that didn't cover the liability, then they go after her separate property interest. No, sorry, not her separate property interest, but her half of the community property. They would not be able to go after her separate property if she had any. I don't believe the facts tell us if she has any separate property. All we know is that there's this family home, and she has a 1/2 interest in it. Okay, so the conclusion is going to be that she will be responsible. Wendy's half interest in the community home is subject to the damages, but only after Hal's separate property is exhausted. But because Hal has no separate property, the pedestrian can reach the family home, including Wendy's interest in the home, but not her separate property. Although we have no facts letting us know whether or not there is, in fact, separate property. Okay? So that would be question number 1. That's how we answer question number 1. Okay? And then we can go 2. Bam. Why does it look like that? See, I want to do this. Why is it giving me a 3? It shouldn't be a 3. It should be a 2. Nope. For some reason, it wants to give me... So, I guess maybe because of this up here. But anyway, it should not be a 3. It should be a 2. I don't know why it's doing that. I don't know. But anyway, it's not supposed to be a 3. I think it's because these are numbers up here because I don't have any other numbers. So why it's not continuing here, I don't know. Which kind of sucks. Anyhow, and we'll do the same thing for Wendy's interest. So now I'm just going to speed through this because we've already put in 52 minutes here, and that's a lot of time. Okay. So for the question number 2, it's asking us about Wendy's interest, the family home subject to the legal fees. So obviously Hal's got no money. He's indigent and his only asset is the family home. And so lawyer offered to represent him, if he gave him a promissory note secured by a lien on the family home, for his fees. And of course, Hal accepts. So he's being kind of a douchey here, but I probably would have did the same thing. But anyhow, the question asks us to answer according to California law. Okay, so we're still in California jurisdiction. So we need to know the rule. So for this to answer this question, we need to know the rule. And a rule that we can use is that a spouse has the power to incur debts that bind the community. Okay, so a spouse has the power to incur debts that bind the community. And so a debt incurred during the marriage is presumed a community property debt. So it's another presumption. Okay, so now we have another presumption that any debts incurred during the marriage are presumed a community debt, unless it is a non-necessity incurred after separation, or if it's a debt arising from the spouse's personal wrongdoing. Okay, and I kind of think husband may be able, Hal would probably be able to, we'd probably be able to satisfy both these, right? It may not be a non-necessity. He may argue that it's a necessity that he has a lawyer to, he needed a lawyer to fight the case against the pedestrian. Remember, this is not a case against his wife for the divorce. He hired the lawyer to defend him against the lawsuit against the pedestrian, right? So it is a necessity. And it did occur after separation, because the facts, so it satisfies the second prong. Remember, she wants a divorce, and then he hires lawyer. However, you could argue in your analysis that it's a necessity. He needs to defend himself against pedestrian, right? However, second prong, is a debt arising from a spouse's personal wrongdoing, right? Well, he was drinking. He was on a drinking spree, and he was, started driving and hit a pedestrian. He was being reckless. So you could say it's his personal wrongdoing. And he ended up having to hire a lawyer and encumbered the house with a lien. And of course, attorney's fees incurred during the marriage are normally payable from community property, unless it's classified as a separate obligation. Okay. Now, the timing of the fee agreement is important. Okay. Hal hired the lawyer after the accident, and after she said she wanted a divorce. Okay. I wrote here, but before Wendy stated she wanted a divorce, but that's not right. She did ask for the divorce. She hired lawyer. He hired lawyer. Hal hired his lawyer, not only after the accident, but also after she wanted a divorce. So I would say he did not incur the debt during the marriage, and the general presumption of community liabilities wouldn't apply. Although there are exceptions if it did apply, and that would be like the nature of the debt, the defense of a separate tort. So although the tort was not for the benefit of the community, the legal fees incurred to defend the tort are also treated as not for the benefit of the community either. Let's see. I'm going to say that the community is liable for the damages. And we did the benefit of the community test, and we determined that him getting drunk and hitting a pedestrian is not for the benefit of the community. However, but contractual obligations arising from defending a tort suit are treated separately. Okay, so fees incurred by the tortfeasor's spouse to defend themselves are generally characterized as that spouse's separate debt because of the tortious nature. Was personal. The nature of it is personal. He's the one who hit the pedestrian. He's the one who was drinking and driving, acting reckless. So those legal fees for Hal, his own personal wrongdoing, which was drunk driving, are not deemed, being for the community or for the benefit of the community. Okay. And then we still have to apply the family home. So we have to talk about creditors. Like, can the creditors reach Hal's separate obligation? So under this type of situation, because it's Hal's separate obligation, the creditor, who is, I guess would be the lawyer, can go after Hal's separate property first, right? And then his share of the community property only if the debt was incurred for the benefit of the community. Since it wasn't, his legal fees are not for the community, the benefit of the community. So that means that Wendy's 50% community property interest can't be reached to satisfy the obligation, because his legal fees are not for the benefit. Why are his legal fees not for the benefit? Because his actions, his legal fees are to defend him against striking a pedestrian when he was drinking and driving, right? So we have to remember that Hal offered the promissory note to secure a lien on the family home, and a spouse cannot unilaterally encumber an entire community property, especially when it's real property, cannot unilaterally encumber the entire home. So the basic rule of this is that one spouse cannot convey or encumber community property, real property, like a house, without written consent of the other spouse. And of course, we don't have any facts in the fact pattern that tells us that there was a consent by Wendy. In fact, the facts essentially tell us that this was not consensual, right? She wants a divorce. She's separated from him. So there's no indication that she would have consented to this. In fact, it's quite the opposite. So that means that non-consensual transfer or the lien is voidable by the non-consenting spouse, who is Wendy, because she never consented to the lien. He did this all by himself. You can see here, he's the one who consulted the attorney. It's not they consulted the attorney. He did, right? To defend him against striking the pedestrian for his wrongdoing, which did not benefit the community. Okay. So that means that Wendy's interest in the family home is not subject to payment for house legal fees, right? It's going to be Hal's separate obligation, and Hal cannot encumber community real property, such as the family home, for example, without Wendy's written consent. So like I said, that lien is voidable as to Wendy's interest. Okay, not necessarily Hal's interest in the community. Okay, so that's how we would attack question number 2. Okay, so we've already determined that her community interest in the family home is not subject to the lien, which I guess you can call an encumbrance. Anyhow, I'm kind of speeding through here because this is turning into a long episode. We're already at an hour, and there's still one more issue with the attorney. Okay, so attorney here, all we know is that lawyer offered to represent Hal if Hal were to give him a promissory note secured by a lien in the family home for his fees. Okay, and of course Hal immediately accepted. So all we know from fact pattern is that the only actions taken by the lawyer is that he offered to represent him if he gave him a promissory note secured by a lien that he's going to pay. He's saying, hey, I want you to promise to pay me, and I want you to use as security, I want a lien on your home. Okay. So we have to really think what rule, now we're in professional responsibility, and they test professional responsibility on every bar exam in the written exam. Sometimes it's a standalone question. Sometimes it's a hybrid question where it has, like this one, where it's community property and professional responsibility. Okay. So it's only one question, but it's loaded. There's only one fact here. There's only one sentence here that even says what he did. All he did was offer to represent Hal for a promissory note secured by a lien on the home. That's all he did. But it's not just about what he did. It's about what he knows, or what we could presume that he knows. He knows that his client, Hal, is getting a divorce. He knows that he was drinking and driving and hit a pedestrian. But he also knows here that he is unemployed. That's important. Why else would he say, I'll represent you if you give me a promissory note secured by a lien? Probably because he knows he doesn't have a job. But the only asset he has is this interest in the family home. So a lawyer wants to get paid. And he's like, if you don't pay me, I'm going to take it from your home. Right? So that's a problem. It raises ethical issues that we have to address. Okay? Conflict of interest, for example. An attorney acquiring a proprietary interest in his client's property, right? So under the ABA rules, a lawyer may not acquire a security interest or other pecuniary interest adverse to the client unless the transaction is fair and reasonable, it is fully disclosed in writing, the client is advised in writing to seek independent counsel, and the client gives informed written consent. So if we were just take that prong by prong, the transaction fair and reasonable, I don't know if it's fair and reasonable. He knows his client has no job. He's unemployed. It may not be reasonable to secure a promissory note when he knows he doesn't have a job, right? Or at least that's an argument that you can make. Did he fully disclose in writing, the agreement? It doesn't say anything about it writing. He just wants something. He just wants a promissory note, but it doesn't say that he put the whole thing in writing. I'll just immediately accepted, right? It doesn't say that he presented a writing, and we can't add facts to the fact pattern. So it's reasonable to infer, since he immediately accepted, that he didn't have time to draft up a lien or anything like that, or a promissory note that how consigned doesn't say how signed anything. Okay. The client is advised in writing to seek independent counsel. Nothing here that would indicate that occurred. And the client gives informed written consent. There's no writing, so he can't give informed written consent, right? And it's asking us to give ABA and California. So under ABA, that'd be Rule 1.8, and for California, under the California Rules of Professional Conduct, that'd be 1.8.1. Okay, and this has a similar writing requirements and informed consent stuff. Okay, and there's no indication that the lawyer complied with these rules. So you can conclude that he violated California's Rule 1.8.1. Okay. There's other issues such as improper acquisition of an interest in litigation. This ABA Rule 1.8I prohibits a lawyer from acquiring a proprietary interest in the cause of action or the subject matter of the litigation, except liens authorized by law to secure fees or contingent fees. So in California, the interest in the subject matter only if it complies with Rule 1.8.1. The lien on a family home is not an interest in the cause of action, so ABA 1.8I is likely not violated, but the lien is improper due to lack of disclosure and consent, as we've already established, right? Fee agreements must be reasonable, as we know, under the ABA Rule 1.5 and California Rule 1.5. Attorney's fees must be reasonable as well. Okay. So that's another one that he violated. Let's see. Duty to explain material risks and alternatives. So a lawyer must ensure the client gives informed consent in the fee agreement. And so the lawyer did not advise how of the risks involved in encumbering a family home and the need for Wendy's consent. He didn't even, he unilaterally, attorney offered him to represent him for a promissory note and a lien on the property without even telling Wendy, right? So there's obviously conflicts there. And you could just keep going down the list. Unauthorized encumbrance of a community real property. Let's see what else we have. We have potential conflict of interest. So the lawyer's personal interest. So by securing a lien in the home, lawyer personal financial interest may materially limit representation. So California Rule 1.7 prohibits representation when a lawyer's personal interest creates a significant risk of materially limiting professional judgment. So the lawyer's interest in the home creates a conflict requiring written consent and informed written consent. So, written disclosure in California or informed written consent, which is both ABA and California. And we know that we could we can safely assume that no such disclosures occurred, which means that's another violation. Okay. And that's basically it. So, if you think about those, we're talking about we're talking about written disclosures. We're talking informed written consent. We're talking about unilaterally entering into this agreement without informing Wendy. He doesn't explain the risks involved and the alternatives to, having to encumber his home. So, all those potential conflicts of interest, whether the fee agreement was reasonable, I don't know, taking a lien on a family home, which is the marital residence, to secure fees from an unemployed client, may be deemed unconscionable or unreasonable under California standards. And I want to make sure that we are clear in that California and the ABA have different language when it comes to reasonableness, or I want to say reasonableness. Let me see if I can find it in my notes. So we're talking about attorney's fees. What I want to talk about is attorney's fees. Okay. Under the ABA, I want to say it's attorney's fees. Under the ABA, the fee has to be reasonable. Okay. I thought I wrote this down. So under the ABA, attorney's fees have to be reasonable. Yes, reasonable. And under the California, they cannot be unconscionable. But I'm going to verify that for you. Fee agreements. Okay. Maybe that's just in my head. But I believe that under the ABA rules, fee agreements need to be reasonable. Okay. Under the California rules, attorney's fees must be, under the California rules and the ABA rules, the attorney's fees must be reasonable. I really want to make sure that I have this here. And if you made it this far with me, just give me a moment. Because I want to make sure that I give you the correct information when it comes to the fees being reasonable versus unconscionable. All right, I guess I didn't write it in my notes, but I'm going to hold firm to my belief that when you're talking about, attorney's fees, or that they have to be, under the ABA, they have to be reasonable, and under the California rules, they cannot be unconscionable. But I can't find that in my notes. So I may have to just give that on another episode. But anyway, that is the episode. We're at an hour, 15 minutes. So let's just end it there. If you have any questions about or comments relating to today's or this episode's question. This was question 2 in the July 2012 bar exam, general bar exam, community property and professional responsibility. So as you're preparing, or as we are preparing for the February bar exam, it's important that we start to build momentum. I know that it's firsthand how difficult it can be working a full-time job, having kids or a family, and how much time that requires. I mean, the job alone, I work full-time. The job alone, and I drive anywhere from, depending on how early I get to work to avoid rush hour traffic. If I don't get out of here on time at 4:30 in the morning to get to work by 5:30, I could be sitting in traffic for an hour and a half one way, right? So that means I need to make good use of my time. I wake up in the morning, I get ready, and I go. To get exercise, you want to stay healthy. I have a hard time with that because I have bad eating habits, and I don't exercise as much as I would like to, but I have to do everything I can to try to get in some reps. I bought me a very expensive punching bag thing, a standalone punching bag that I punch to try to give me some exercise. I try to get in the morning when I get to work. I try to do about 10 MBEs, even if it's just 10, and try to work on the ones that are really difficult. Write down answers, outline bar exam questions, because there's just too many to go over, and you don't have. It's very difficult to, especially if you work full time and you have kids like I do, to draft full blown 1 hour questions. I'm not saying you shouldn't do that at all. I mean, you got to have a plan. Be on a daily plan, learning and memorizing rules and understanding fact patterns, how to spot issues, issue spotting, how to knowing the rules for those particular issues, and then understanding how to give it an analysis is very difficult, especially with limited time. So I know what you're going through. Just keep your wits about you. Keep doing as much as you can every single day. Don't let a single day go by without doing something. Even if it's just one MBE question, even if it's just reading one fact pattern, something is better than nothing. One thing I've been watching is these videos, these Japanese videos, where they talk about basically they're talking about micro habits, which I found has been very useful trying to implement new habits as opposed to trying to change my whole life around just like all at one time. Could be very difficult. Your brain's going to tell you like, no, this is just too much change at one time. No, I can't do it. So we just try to implement one little change each week or each day. I've been trying to wake up at 4 a.m. every single day on time. I always wake up at 4, but sometimes I snooze. And so I know that every time I snooze, that's 7 or 8 minutes later, I'm going to get to work. So if that I want to, because I want to get out of work early. And if I go in early, I get out early. My boss has been complaining that I go to work too early, but he gets it. He knows I'm hustling, So just keep it going. If you guys have any questions about today's lesson, or if you have any comments or feedback, I would greatly appreciate it. I would also appreciate if you give a like or a comment in the description, or a sub. That'd be super dope, right? And I also have another channel, JB Rambo Show. This is the Legal Doc Guy podcast, but I have another show called the JB Rambo Show. I'm going to be starting that up again soon. I'm also about to get some software that I could do, more stuff instead of just, right now I'm using a program called OBS Studio. It's very limited as far as I'm concerned, as opposed to something like StreamYard, where I could, it's just a better program, and I could do live streams, and I could also do reaction videos, all that kind of stuff. So anyway, thanks for watching. If you made it this far, put a Cal Bar sucks in the comment section, so I know you made it all the way through the hour and 20 minutes. And I'll see you guys on the next video.